Hello, everyone. I think I've met some of you before, but for those who have not met you before, my name's Ifat. I am one of the services managers for Citizens Advice. We have two offices, and I am looking after basically the phone service that runs out of Shorten and Wallington. And during COVID, we were inundated with telephone calls with regards to sudden people passing away or becoming ill, and together we had to come up with some a whole bank of knowledge that we didn't really talk about before. And so today's talk really is around wills and inheritance, and it comes about from some of the questions and queries that we came across during COVID and post-COVID, obviously now. So this is what that's going to be about. Okay, so really it's going to be about wills and inheritance and the importance of them, and what happens if somebody doesn't have a will, and what happens after somebody passes away in the processes. I'll just caveat everything by saying we're not solicitors, we're not lawyers, so we're not going to be providing any kind of legal advice. What we can do, and what this is really about, is just about information about how what the processes are, and I'm happy to take questions at the end. Okay, so the introduction. So what is a will? So a will is really a legal document that outlines a person's wishes regarding the distribution of their estate after they pass away. It's not, it doesn't have to be through a solicitor. And we will come into what makes a will legal in a moment. But really, it's the piece of paper that allows somebody to put their wishes and what they would like to happen after their death into place. It should also reduce, hopefully, family issues. And that is one of the big phone calls that we do get, is about issues arising from death and wills and not having a will. And also, if people are well off enough to have a nice estate, it can also help with tax planning and with help people financially plan for the future. So why do we need to have a will? Without a will, the law makes a decision as to who will inherit, regardless of whether anyone thinks that's fair or not fair. We've often seen this happen with regards to people who are not married. So there is an assumption that if you have been living together with someone as a partner, that you have somehow the same rights as somebody who is married or has a legal relationship. Unfortunately, that is not the case when it comes to inheritance and this distribution of an estate. So we've often had phone calls. For example, somebody has called up and said, oh, I live in a house that's owned by my partner. He had children from a previous marriage. He's now died without a will. The house was in his name. His children are saying the house is theirs. Is that true? And we actually have to say, unfortunately, yes, it is. Unless there's a will that outlines, if you are not married, what is distributed to a partner, then the law kicks in, and then unfortunately there's no legal standing for someone who's just been together, living together with someone, even though they've lived as husband and wife, or husband and husband, wife and wife, for their entire a large period of time. It means nothing when it comes to inheritance. So with a will, you can appoint the person that you trust, whether it's a family member or a professional, to what they call execute or become executors to make sure that your wishes are fulfilled. And you can also decide what happens to your property, to your money, to your car, to your jewelry, to that favorite teapot that somebody may have. that you want to give it to the right person. And also to provide for children, and especially if there are dependent children, and people may come, as we're talking about death and things, to that there may come a point where you have young children and you are facing end of life. So a will be able to write very clearly as to where those children who will become their guardians. So, who can make a will in the UK? It's fairly straightforward. It's somebody who's over 18, but the second criteria is have to be of sound mind, which is of where you are able to make decisions for yourself. This is something that if you don't have capacity, unfortunately, a will not be made legal, and potentially it is too late at that point then to make a will. So it's kind of important, especially when people are maybe have an early diagnosis, for example, of Alzheimer's or dementia or any other life-limiting illnesses, and maybe in the future they may not be able to make decisions for themselves. To have one of these as to have a will. We always talk with wills as well. We talk about potentially power of attorney as another document, but that's not in today's talk. But it's again just documents that make it easier for the people that are having to deal with your affairs to have the legal right to do so. Truthfully, you don't need, like I said previously, don't need to go to a solicitor to have a will be legal. It needs to be witnessed and signed, and there have to be two independent witnesses who are also required to watch you sign. And have to sign the document as well. One of the caveats for being a witness is that you cannot also then be a beneficiary. So it can't be like, oh, I'll get my son to help sign it, but I'm leaving him the house as well. So it's got to be someone completely independent, maybe a neighbor, friend. If it's solicitors, then they will sort that out for you. But yeah, you cannot be a witness and a beneficiary at the same time. So, like we said, it has to be written, signed, and witnessed by your two witnesses. And this is the reason why it has to be very clear that somebody had capacity to make that will, because a will going forward can be contested if somebody thinks that there was coercion or that there was somebody who was not in their right mind and a will was written for them. So for a will to be legal, it does have to be done without any undue influence or fraud. So it can't be you just wheel someone in to sign something, scribble something, and say, "Oh, I witnessed them," and there may have been an issue with their capacity to actually make those decisions. And they do try to say make the will to be clear language and specific instructions. I know a lot of solicitors, when they used to write wills, was a lot of therefores and their words and forewords. And so now that you can sort of plan what you would like to say in your will. So it's very clear to whoever is going to be looking after your affairs what you would like to happen. We will say that there's where you can get wills done. So obviously you can write it on a piece of paper and get it signed. If you have a very straightforward estate, there's nothing that you're leaving, but maybe there's some wishes that you would like to have, like how you would like the funeral to be, or how you would like to, distribute the few little pieces that you may have. It can be as very straightforward as a piece of paper. More complicated ones, like if there are homes, estates, if it's not very clear cut as who you may want to leave it to, we do recommend you can speak to solicitors. Will writing services are available as well, but a solicitor, one of the other things that is available there's twice a year, there's things called Free Wills Month, which you can sign up. I think it's March and October, where you can actually sign up to actually have your will written for free through various different charities. And then you can potentially leave something in the will for them. I think St. Raphael's has one as well, where Yeah, where you can potentially have someone write your will, but in it you just put in that after I pass away, I leave a certain amount to whichever charity of your choice. And a number of charities do this throughout the year as well. So people like Cancer Research sometimes do it. The Alzheimer's Society, I know that the RNLI do a lot of it as well. So it could be something that if you don't want to go to just a local firm, but you're actually quite involved with a charity, or a charity is close to your heart, you may want to see if they do free will writing services, with maybe just a caveat that you leave them a gift in your will. A will is that if it's not changed, that is what it was used to be called the last will and testament. That is your last wishes. A lot of people will write a will and then just forget about it. But you can revisit your will if something major happens and you think, actually, my life decisions or the way that my life is running right now is very different to when I wrote that will. For example, somebody may remarry, somebody may have more children, somebody may fall out or get a divorce. So it is good to have revisiting your will. You can't just change it completely. It will be something called a codicil, or an amendment that is made to the will afterwards for any little or certain changes that you need to make. If it's a huge major change, like you're rewriting your will entirely, most solicitors will ask you to actually start a new will, make a new will, and that then supersedes anything that was previously written in your name. One is that when people write a will, it would be really useful if they told the people that potentially their executors, so that where they have kept a copy of that will. We have had this numerous times where people say, oh, I'm sure my mum wrote a will, but I don't know where it is. And that does cause real contention, because you may have a will that is setting something out, but without a physical copy of it, there could be that, Archer, we're just going to have to go down under this. What happens if there's no will? Unfortunately, there's no central register at the moment for wills. And I think that is because people do change them. So there's no central register with wills. But if you are picking somebody to be your executor, or if you've got friends that are going to write a will, then just at least let them know. You don't have to let beneficiaries know. And actually, no one has the right to see a will except for the executor, actually, until probate. It is a document that does not have to be bandied about by everyone. But as long as somebody knows where a copy of it is, or who your solicitor is, or who you may have written it with, then that would be really useful. From personal experience, my father very suddenly passed away, and we were under the impression that he had a will. But we were very, very lucky that I was thumbing through an old file that was, weirdly enough, in my name, in his office, and it had like documents from my life. But in the middle of it was his will and testament, last will and testament. If there isn't a will, what happens then? It is called intestacy. It is there are very specific laws as to what happens to the entire estate if there's no will. This is where I was talking about previously, like the person who inherits really is the spouse, the children, and other relatives, depending on. But the first right goes to a spouse. Now, that could be somebody who got married last week to that person, and then that person suddenly died, not left a will. And it might mean that the rest of the family do not receive any inheritance. This is where that issue with when they use the word spouse is really important to know. It is either a husband, a wife, or a civil partner. So whichever way that setup is made, but that has to be a legal relationship for it to be counted under spouse. If not, then unfortunately there's no automatic right of inheritance unless there is a will. So if there's no will, there's no right of inheritance for a partner, even if you've been together 20, 25 years. If there's no wife or husband or civil partner, then it will be distributed to any children. And there's like basically what we call a hierarchy of inheritance after that. I have put down, there is a website which will, you can, it's quite easy to calculate who would get that. We do that for quite a few clients. But again, this question keeps coming up because we get a lot of clients who call up who don't understand that having a will means, or what not being married means, because all the other things like your benefits and everything else are paid as if you're a couple. They don't mind if you're married or not married. But when it comes to inheritance and certain other things, that legal relationship becomes really important. I will also say that if it's children born outside of marriage, that's not a problem. It's just the spouse bit that is the important bit for this. So what happens once you've had a will? So there's a will, it's in place, your loved one passes away. Then there's a process called probate. And probate is basically the legal process, or the getting the legal right to distribute someone's estate. Not everyone needs to go through probate, actually. You may have somebody may have a very small estate. So like under £5,000, there's no house, there's no car, there's just a few £1,000s in the bank. You may not need to go through probate for that. With other people, if there is like properties, if there is savings, if there's money, investments, shares, expensive jewelry, if the value is above a certain amount, which is normally £5,000, then they will say you do need to apply for probate. So we use the word probate, which basically means that you are it's normally done the executor who is in the will. They will apply for this. It's their legal right to start to distribute the estate. It's one of the reasons why distributing an estate can take a long time, because there's a big, long process to go through before anyone has the legal right to dispose of an estate. We have to check about inheritance tax. I will go over some of the very basics towards the end of this presentation, but not a tax advisor, but we'll just go over some of the limits that are there. And the same process is involved if there isn't a will as well, but there is an estate. With that, that's called letters of administration. And again, it has to be a close relative that can apply for those letters of administration. It's the same process as probate, but it's just a slightly different wording. And it just allows you to, again, legally deal with someone's estate. Once probate's been granted, the will then becomes a public document. It can then be viewed by anyone and everyone. And there is a search facility on the gov.uk page where I think you pay about £3 and you can download the entire will and and check who has been granted probate for that. So you can do that. You can go back, and it's a lot of way we can work out what sometimes people use it when they're doing, ancestry and genealogy and stuff. So they do it through there. Yeah, you can go quite far back. You want your will becomes a public document once probate has been granted. So and you can go find it, and it sits there on their system, and you can pay for it and download the documents that are attached to it. I'm not sure if our current Chancellor is changing the inheritance tax bandings or rules right now, but this is where we currently stand. So inheritance tax is tax on property and estate and money. Your normal threshold is currently is 325,000. So if you've got an estate that's worth less than £325,000, there's no inheritance tax. Also, anything above that potentially is taxed at 40%. There are loopholes around that. So, for example, if you have a house and your children are inheriting it, maybe after both spouses have passed away, the tax threshold does go up to around about 500,000. So we would suggest that if you do have a complicated or an expensive estate, that is something that you discuss with the solicitor to see if there's any inheritance tax to be paid. If one spouse passes away and the other person is a joint owner of a property, there's no inheritance tax at that point. That is tax-free. Anything left to a spouse is sort of tax-free. Okay. I've also put in the inheritance tax helpline if anyone in the future needs to be contacted. And that is run through HMRC, and they are specifically there to help questions about what your inheritance tax liabilities may be, what forms need to be completed. An inheritance tax and everything needs to be paid. Any debts need to be paid before the beneficiaries can then receive what is left for them. So the estate, you may look like it's very, very big and there's lots of money there, but once executors have to confirm that all the debts have been paid to anyone that's outstanding, then any tax, inheritance tax has been paid, and then what is left over is then distributed among the beneficiaries.